So, you know, about 4 years ago, I was involved in a very bad car accident. To this day, I do not remember the car accident. I remember like the OnStar system talking to me and having no clue why some lady was talking to me. Um, Thankfully, she had already called an ambulance. I remember a cop encouraging me to get out of the car, kind of get me out, and then laying down in the grass. And it was really fuzzy. And again, I had a bad concussion. And for about 2 months, my short term memory wasn't great. And I remember my wife telling me, "Do you remember going to the doctor and talking to him?" And I'm like, "Nope." You know, again. But during that time period, because I had a power of attorney naming my wife as my agent, and I had the appropriate documents naming her as my healthcare surrogate, she could go to my doctor's appointments and make decisions that I just could not trust my mind or my memory to make. She could handle financial matters on my behalf over that, time period. Now, as my concussion subsided and my memory got better and things happened, positively for me, her need to use those documents subsided. But for about 2 months, the very documents that I encourage people to have, the very documents that I draft for others on a routine basis, I actually needed for myself. Thankfully, I had those documents and they were critical at that moment. I'm not a retiree. My point is, we don't know what's going to happen, when it's going to happen, and what you're going to need someone else to do on your behalf. This even includes a HIPAA waiver. If you have children or grandchildren who are in college, so there was a school shooting, and this happened a while back. My clients, their daughter was one of the people who was shot. Now, not fatally, she was shot in the arm. She was going to make full recovery. But when the incident first happened, all they knew is she had been shot. And they knew that she had been transported to a hospital. They called the hospital. First thing out of the person's mouth that they talked to at the hospital was, "We need your HIPAA waiver so that we can talk to you. We need the HIPAA waiver signed by your daughter saying that we can release her information to you." They didn't have one. And they were denied any information on their daughter, even though she was in surgery. They got in the car. They drove as fast as they could to get to where their daughter was going to school, to that town, and got to the hospital. And their daughter was going to make a full recovery. Everything was fine. But they didn't know. And for 6 hours, they drove not knowing. And my point is, 18 and over, you need some type of estate planning documents. Now, when my niece turned 18, she got a power of attorney. She got the advanced healthcare directives. Did I get her a will or draft her a will? No, because she really doesn't have any assets. And she's not married, doesn't have kids. And if she died, anything she owned would go to her parents. Okay, so again, it was one of those situations where I wasn't really too worried about the asset side of it because she would have done an estate plan anyway, saying, "Leave it to my parents." Now, let's talk about the fifth and final myth that I wanted to address in this podcast. And that is, joint ownership solves everything. It depends on how it is held jointly. It depends on who you hold it jointly with. It depends on the type of asset that you hold jointly. There are so many variations of this that, once again, I could go on down a huge rabbit hole trying to explain all this. But instead, let's step back and let's talk about some real world examples. So my wife and I, we own all of our assets joint. We own all of our debts separate. Now, we own our assets jointly as husband and wife. Why is that important? Under Florida law, when a married couple owns assets jointly, then my individual creditors cannot come after anything I own jointly with my wife. I like to shoot. And let's say I go to the shooting range, I'm not paying attention, and I shoot the guy in the foot next to me on the range. Now, I was dumb. He's going to sue me. And you know what? He should. But he can't come after anything I own jointly with my wife. So joint ownership in that instance, awesome. I die, my wife owns it. She doesn't have to pay any of my debts. It's beautiful. It's a wonderful thing. Now, let's take it a step farther though. You have an asset and you say, hey, I want to put my child on it. I'm going to own it jointly with my son. The number of times that I see this and I ask clients, why did you do that? There are a couple of answers that really are the top answers. One, well, I wanted them to have access to the account because if something happened to me, they could pay the bills. So in other words, you put them on there as a matter of convenience. Two, I wanted them to have it to void probate and they know what I want to do with it. Well, let me tell you, again, the best laid plans don't always fall exactly where you think they're going to fall. About 5 months later, my client calls me and says, hey, my daughter got sued and they took the money out of my account. Can they do that? Now, what do you think my answer was? No, yes. My first response was, tell me about the account. Not a yes or no, but tell me about the account. And she proceeded to tell me, well, you know, I named my daughter as agent under the power of attorney. When I told her that, she said, Mom, it's just too complex to use a power of attorney. Just put me on your account. Just make me a co-owner. You know, it's just going to be more convenient that way. Except daughter didn't tell mom that she was currently facing a lawsuit over an unpaid bill. And guess what? They got a judgment against her. She didn't have any money in her own accounts. But her name was on the account with mom, so where'd they go? They went and took the money and they garnished it on the mom's account. Now, I told the client, I said, hey, we can pursue litigation to recover that money to about $9,000. It's probably going to take you $4,000 to $5,000 in legal fees to recover the $9,000. Is it worth it? Do you want to spend that kind of money? Because if you lose, now you're out $13,000, not $9,000. She ended up walking away from it. All because her daughter said, oh, don't make it so complex. Why name me as agent under power of attorney? Just put me on the account. That didn't work out so well. Okay. And I'm not saying daughter did that intentionally. I think daughter honestly thought, well, that's mom's account. I'm just on the account as a matter of convenience to help mom out. Not knowing that, oh no, now you have ownership rights and therefore daughter's creditors can come after it. And you know, and again, I hope that that was the thought process, not, hey, I want to get rid of this creditor and have him go after mom's account, not mine. But I honestly don't think that was the case. I think she honestly thought, well, it's just a matter of convenience. But this is where the law of unintended consequences kicks in. Now let's use another example. Guy had 3 kids. He said, I'm going to skip probate. I have 3 CDs, CD1, CD2, CD3, each of them with a couple of $100,000 in each. And he has 1 child who lives close. The 2 other children live farther away. And he was using a local regional bank. Okay. And now dad dies. Daughter collects the money on all those accounts. And you say, how? Because dad made daughter the co-owner. Now, here's the funny thing. So it was dad and daughter. pay on death to daughter, and the second one was dad and daughter pay on death to son, dad and daughter pay on death to other son. And he died. Daughter didn't die. So guess what? The pay on death provisions didn't apply. And she retained me as her attorney. Met with her. And she asked me, she said, hey, I own those accounts now. Do I have to give them to my siblings? And since she was my client, I can't lie to her, and I wouldn't lie to her. No, those are your accounts now.